Hello all, welcome to our panel discussion today. We are here to discuss Vidhi's research on violence against women. Over the next hour, we are going to discuss Vidhi's findings on violence against women and have our three panelists discuss their research and their opinions on violence against women. We have three distinguished panel members today. Ms. Reem Al-Salum, she is the United Nations Special Rapporteur on Violence Against Women and Girls, its causes and consequences since 2021. She is an independent consultant on gender issues, the right of refugees and migrants, transnational justice, and humanitarian response. Previously, she worked as an international civil servant working with the UNHCR in 13 countries. Our second panelist is Dr. Sharon A. Bong, who is a professor of gender studies at the School of Arts and Social Sciences, Monash University, Malaysia. She has authored Becoming Queer and Religious in Malaysia and Singapore and co-edited Gender and Sexuality Justice in Asia. She has facilitated gender sensitization workshops for the Malaysian Bar Council and refugees community leaders with the UNHCR. Ms. Vita Wenjere is an international development professional and consultant with experience in project management and implementation in the Southern African nonprofit sector. She has extensive experience in international development with a focus on research, project planning, and implementation in sexual and reproductive health, gender policy, analysis, and violence against women, prevention and mitigation and responses. Welcome all of you. I am very happy to have you here today, and I look forward to a very interesting and engaging discussion with the three of you. Our panelists will present their presentations for 10 minutes each, and then we'll have a discussion between the four of us, and then we'll open the floor for Q&As. I request the attendees to post their questions in the chat box so then we can take them up at the end together. With that, let me begin with our findings on violence against women. Is the PPT visible to everybody? All right, great. So our question was, what is the state of violence against women in India and how have we gotten here? Crimes in general, reported crimes in general have been reducing, but crimes against women have been rising over the last 2 decades, from 1,41,000 to about 37 lakhs in the last 20 years. So the question is that despite enactment of new laws, we are still continuing to see violence against women as a core problem in India, and spaces continue to be unsafe for women. Public and private spaces continue to be unsafe for women. So we try to understand what the governmental response to violence against women had been, and what the consequences or how this had played out on the ground. So the first question was the legislative thinking behind legislative thinking behind laws relating to violence against women. The second question was how the executive has implemented the legislative intent in creating safer spaces for women. And the third question was, how has the judiciary interpreted the laws and have they been in favor of women? So we have seen that since 1956, 17 new laws have been passed relating to violence against women, starting in 1956 on suppression of immoral traffic against women and children, against women and girls, sorry. This went on, and then over the last few years, we see a flux of new legislation being drafted, the most relevant or the most talked about being the Criminal Law Amendment Act of 2013. And then, of course, more amendments to Protection of Children Against Sexual Offences Act and the Indian Penal Code and CRPC, etc., all to make or to create more crimes, more offenses that relate to violence against women, including voyeurism, stalking, acid attacks, etc., and also increasing the penalty towards violence against women, like introducing death penalty for second rape, or introducing death penalty for certain cases of on violence against children. So we have seen a rising trend of increasing punishments, more offenses, and more focus towards deterrence. What we found, especially in regard to legislative thinking, was that initially in the 1950s and 60s, even while enacting law, the legislators they knew, or they were very cognizant of the fact that law can only do so much, and that there needs to be a social change to be able to actually combat violence against women. So even though they thought legislation was necessary, they knew that legislation can only act as a little piece of the larger puzzle. Today, we see that deterrence has become the mainstay, and invoking stricter and stricter punishments has become the response that the government has towards crimes against women. In parliamentary debates, we see people asking for public castrations, more death penalty, all towards making crimes and punishment more and more and more severe towards offenders. In executive action, we see that even though a lot of structures have been created for under legislation, for example, special courts and special prosecutors and protection officers, probation officers, etc. In practice, most of these remain just on paper. One was that states are reluctant to even answer the question as to how many of these bodies have been created, because if you see that 6 states responded out of the 16 states that we had asked questions to, and then very few of them have actually made any appointments. Same thing with trafficking police officers, only 5 states out of 13 states responded. In which only 5 states have made appointments. Similarly, a state with special courts and dowry prohibition officers. What we also find is that these ancillary officers, like protection officers, prohibition officers, etc., these are supposed to have very, very specific functions, like dowry prohibition officers are supposed to work only for dowry prohibition, or domestic violence officers to help women who have been suffering from domestic violence are supposed to work only on that particular subject. But we see that they've been given multiple portfolios. So appointments are weak, and only a small percentage of the actual number is being filled. And even within that, they seem to have multiple positions. So they work for children, they work for women, they work under different laws, and they don't actually have the capacity to take care of any of these anything that they've actually been appointed for. Similarly, budgeting is a problem, because if you see Nirbhaya Fund, which happened after the 2012 attack of the same name, it released or had projects was 9,764 crores, but only 4,087 have been released, and 2,871 crores has been utilized. So money is hard to come by. When it does come by, only a percentage of it is released, and even a smaller percentage of that is actually being utilized. Then judicial action makes it even more worrying, because the law in itself is very patriarchal and protective in its notion. It does not provide agency to women. All it does is to seek to protect women from violence, but it doesn't tell us how to empower women or give women agency to protect themselves. Now, there's a flawed way of approaching this problem in the first place. The judiciary makes it worse. So we looked at rape cases, and out of the 263 rape cases, we found 90% of the cases the accused was known to the victim. Now, this is relevant because laws are drafted often on the assumption of stranger rape, which is usually not the case, as this tells you. And then 42% of these cases were promise to marry cases. Promise to marry cases is a very specific thing that happens in India, where if a man has promised to marry a woman, and on the basis of that, the woman has had sex with him, and then he renegades on that promise, and he doesn't marry her, the woman can take him to court, and this can be considered to be rape. This was a Supreme Court decision. What this has done, that it has trickled down to lower courts, where most of the cases that are coming to them are promise to marry cases. This becomes an issue because courts are not even incentivized to consider the question of consent, because they're so used to looking at these cases on a day-to-day basis that they don't even bother to look at the issue of consent, which has become a prominent feature of the Indian Penal Code, of the rape law. So even though the law provides for it, judges are not incentivized to even consider the question of consent, and that's hugely problematic. The other thing that we had looked at was cruelty cases of Section 498A of the Indian Penal Code. We thought to look at this because this particular provision has become very notorious because it's considered that women use this against men to harass them. But what we found through our research was that most cases are actually leading to acquittal. Since 2018, only one person has actually been convicted of cruelty, even in cases where the woman who has often died in these cases, because these cases usually come to the court when the woman has died of self-injuries, of maybe murder, we don't know. But even in those cases, we are not seeing any conviction rates because courts have a very high standard of evidence. And most witnesses are not able to meet that standard of evidence. And so even this very notorious provision in reality is not actually leading to conviction. So it is actually not being used by women who actually are in need of this provision. So we find that laws or depending only on laws is not sufficient because it cannot account for the realities of day-to-day living. It cannot account for women's lack of access to the justice system or the violence that they face within trusted spaces. How do they step out and how do they step out and seek help when the violence is happening within their closest, most safe spaces? It cannot account for situations where the judge incentivizes people to settle, or when the parties are incentivized to settle or marry their rapists. It does not account for that. Therefore, law, to our mind, is entirely insufficient to make society comfortable for women or safe for women. So this is what we find. Now let's have our panelists tell us what their experience with law and social justice has been with regard to women. So let's start with Reem, and she can give us inputs from her extensive experience on what violence against women across the world looks like and how can we think to actually alleviate this problem.
Thank you very much, Neha, for inviting me to be part of this panel with all these distinguished panelists. It's really a pleasure to be here. It's the first time we collaborate in a seminar of this sort, so this is a great opportunity. So I was requested to speak more to the issue of access to criminal justice and what are the barriers, let's say, to an effective access to criminal justice for women and girls that are victims of violence. And allow me perhaps to pick up from what you said by also reminding ourselves that violence against women and girls is an epidemic of really high proportion. We don't have, of course, enough data. We know that 1 in 3 girls and women at least have experienced some form of gender-based violence, mostly domestic violence or intimate partner violence by someone you know, as you rightly said. And all I can say is that this bleak picture is exacerbated these days by the multiple crises that we see around the world. We've had the COVID crisis that we know has increased violence against women and girls, especially domestic violence. We have the food crisis that is also exacerbated by the war in Ukraine, unfortunately. We have the climate crisis, and I've spoken at length about the relationship between the climate crisis, environmental degradation, and violence against women. There is a report I presented on this last year, plus the proliferation of humanitarian crises around the world. So really, if anything, the situation is bad and it's going to get worse. When it comes to access to justice, I would say that what is clear is that access to justice cannot be addressed as an isolated piece of the puzzle, but has to be addressed holistically. For victims to have meaningful access, so many other things have to be in place and have to fall in place. One of them is, as you rightly mentioned, you could have the best legal framework in the world, the best legislation, most comprehensive, but if there is no operational arm, if there are no resources attached to it, it's like a person without teeth. They are going to be very, very disabled and unable actually to really implement or operationalize these laws. And in addition, I would say that before we even speak about justice, and often before victims can even think about justice, the first thing they need is immediate care and support and protection, so that they can start to at least deal with the immediate effects of this horrible violence they've been subjected to, in terms of psychological trauma, in terms of physical consequences, problems, and also the threat might continue to exist when it comes to their physical safety. So I would say having adequate assistance and protection for the victims is key before even we can speak of justice. And of course, related to that is that whatever processes are in place for assisting and protecting the victim, they have to be victim-centered. All too often, we find that processes are not sufficiently victim-centered or victim-sensitive, where it involves children. There is no child-sensitive approach. There is no attention given to confidentiality, to safety, to no re-traumatization, to avoiding victim blaming. And here I want to say that the media, unfortunately, also often plays a really detrimental role when incidents of violence are covered. They often tend to fuel all these problems and concerns. And I think that adds to the barriers that women experience if they've been subjected to violence, and increases the barriers about reporting violence. I also want to say that the barriers for accessing justice for women are not the same. Yes, in general, it is more difficult for women to access justice, but even within the group of women and girls, depending on the countries, and in each country, there are groups of women that face higher barriers because of the already intersecting forms of discrimination that they experience in a society. So they might face discrimination and violence because they are women, but add to that also the fact that they might belong to religious or racial or ethnic groups, or be of a particular faith, or have a specific sexual orientation or gender identity. So when these elements come together, we will see that therefore women from certain groups might find it even harder than the group of women. And then, of course, you have, therefore, the issues of language, distance, lack of resources for these women, the stigma that they may experience by their society, by their family, by their partners, the lack of knowledge on what they should do if they want to even think about justice issues. And then also I want to come to the whole legal framework, which, you know, we could take another 3 hours to talk about this, but I'll just briefly mention that, of course, in many legal frameworks, and you've just alluded to them also, Neha, there can be so many problems in, first of all, how violence is defined, how comprehensive it is, how consistent it is with international human rights frameworks. So, for example, in many jurisdictions, femicide or gender-related killings are not criminalized in national criminal law. Rape, for example, the definition of rape is not comprehensive enough and would, for example, be restricted to only, let's say, rape committed with a sexual organ. Domestic violence could, for example, leave out intimate partner relationships, or, for example, could leave out people that live in your household but that are not your spouse. Then we see also the issue of statute of limitations that are part of many systems where therefore it introduces a limit, a time limit, after which a victim basically cannot come forward because it's futile, because it would not be admitted. The fact, for example, that mitigating circumstances can be introduced that allow to reduce then the penalty for a perpetrator of violence, sometimes even applied retroactively and applied selectively in the case of, for example, violence committed against certain marginalized group. The perpetrator is then released more easily on bail, or is gotten out of prison because of good behavior, and of course this is detrimental. And would really sends the message, A, that violence against women and girls is not taken seriously, B, that it's applied selectively, and therefore justice is an issue that is applied selectively. And 3, that it discourages you from even coming forward because it will really not lead to what you are expecting. And then, of course, there are other issues that are problematic, like, for example, as you said, Neha, the issue of consent is not central to a lot of the legislation. And in some legislations also we see that there's an obligation, either in law or practice, to resort to mediation first, which, by the way, should never be enforced on a victim. Other pieces of the puzzle that has to be addressed as we work on criminal justice and legal justice is addressing underlying social and cultural norms. You know, any legal system doesn't work in a vacuum. It works within a context. And if the context is problematic, patriarchal, full of misogyny, then the legal system will also reflect that. So we have to continue to work on that. And of course, it's a long-term process, but we have to work with all of society, religious leaders, men and boys, community leaders, the media, and so on and so forth. I also want to spend just a couple of minutes on the issue of gender stereotyping in the judicial system, and link it also to how much it can be influenced and impacted by the patriarchal norms that exist already in society. So we know that the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, one of the central points is non-discrimination and equality before the law. And CEDAW also asks parties to member states to take all measures, including through legislation, to abolish existing laws, regulations, customs, practices which constitute discrimination. And this obligation also extends to all branches of government, including the judicial branch. And in fact, another body, the Human Rights Committee, when it commented on the International Covenant on Civil and Political Rights, said that when it comes to the issue of impartiality in law, in legal processes, judges must not allow their judgments to be influenced by personal bias or prejudice, nor harbor preconceptions, and that they also must harbor preconceptions before them, nor act in a way that improperly promotes the interests of the parties to the detriment of the other. And here I want to say that a lot of persons working in law enforcement, in the judiciary, in many countries around the world, irrespective where they fall in the world, have gender stereotypes. And many of these stereotypes, they harbor them even, I would say, subconsciously, willingly, voluntarily, and they have a huge impact on the way they approach cases, in the way they approach victims, and in the way also they deliberate. And I think we need to have data on the impact of gender stereotyping in decisions. We have to analyze judicial reasons in order to come up with the evidence and the impact of that. But also we have to ensure that there are more women judges and prosecutors in all their diversity, of course, which will help also improve and incorporate gender lens. And also among law enforcement, we need that for sure. Finally, I would like to say that, and you just mentioned the disaggregated data is really a serious issue across the board, not only disaggregated by gender and sex, but also, the type of crimes committed, the relationship between victim and perpetrator. I talked about femicide. Very few countries still collect data on gender-related killings. And as a final note, I would say the issue of justice, defining justice for who, how does justice look like? In order to arrive at that answer, we have to, of course, involve victim organization, women organizations, and all their diversity in designing the most effective ways of accessing justice. And part of justice is also having effective transformative reparations in place. So reparations that will not bring the victim only back to the situation they were in before the violence happened, but really that transforms their lives and also transforms in that the gender relationships. So a lot more can be said, but I don't want to take more time. So thank you very much.
Thank you so much, Reem. I have so many questions to ask. I will hold my questions till the end of everybody's presentations, but thank you so much to think about. I have a feeling that there'll be certain things that everybody will touch upon, because not just as practitioners or as researchers in this field, as women, I think it's we have experienced a lot of the gender bias and violence, micro-violence in our lives, and we have also found it difficult. I don't think anybody, even from our backgrounds, thinks to access the justice system because it just feels so elusive. So on those, I have more questions to ask, but I will come back to this later. Thank you so much. Sharon, can I invite you to speak about what you have learned and what you can teach us?
Thank you so much, Neha. Thank you so much for your presentation, Reem. I think there are some parts of our presentations that may overlap. I firstly want to start by thanking Vidhi Center for Legal Policy for inviting me. And when I was first invited, I did say no, because I didn't think that my expertise would be relevant, and because I'm not a lawyer and I don't directly deal with legal matters, but I was strongly persuaded, and here I am, and very honored to be here. And
thank you so much. I'm glad my persuasion worked.
It did, Neha. You're very persuasive. But I also want to congratulate the Vidhi Center for Legal Policy. I was, looking through the links that you had sent, and the center leaves, as a think tank, it leaves an impressive footprint of impact and significance. And I want to wish you all the best. And I hope that this evening's panel discussion will afford, some rich, perhaps controversial issues for discussion. And as you so correctly said, Neha, in your introduction of me, that so much of my work centers on the intersection of religion and women's rights, or religion and sexuality rights, which is the name of the book that you read out. So why am I so hung up on religion? Rim made a passing mention to it. And in order to talk you through perhaps my approach to tackling fundamental legal questions would be in these slides. So, and I'm mindful that this is being translated, so I will speak at my usual pace, which is measured and slow. All right, this are my slides, and let me just get rid of the floating controls and start the slide presentation. Okay. So the title of my presentation today is Feminist Critical Relativism, an Intersectional Approach to Gender Justice. So it seems like a mouthful, but I will unpack what I mean by feminist critical relativism and hope that as one of many solutions, which is an intersectional approach to gender justice, that those of you who deal squarely with the law may find useful. And also members of the public whom I understand are present here today. This is a three-part structure of my presentation this evening, and it's a fairly short presentation, so I will try not to be too ambitious and, cram too many things in it. The framework is necessarily a feminist one, and because that is the basis of intersectionality, I present the problem. Why do we, get into many deadlocks or many impasse? And that has to do with something that Rim has already mentioned, the cultural and religious, what is usually imputed to be barriers and religious or cultural barriers running headlong or, headlong collision with the law. And this is my offering of one among many other solutions. It's a messier approach, but I think it's an efficient, it's an approach that works because it presents a holistic approach to complex issues. So the framework. The Center for Legal Policy may not name feminism as its, framework, but the fact that it talks about patriarchy and when Rim had mentioned the need for sex disaggregated data, I'd like to think that, they're working either implicitly or explicitly within a feminist framework. In my own work, I have used feminist theories across several areas of study. Religious studies is one, gender studies is another. I started out as a student of English literature, and we overgrade that to feminisms. I sometimes find myself veering towards feminist jurisprudence as a matter of interest, but I look to feminisms, problematic as that is, and there are many among the young who may shy away from the use of the F word, but with regard to feminisms, it has named the fundamental problem of violence against women or gender-based violence as one resting on gender binaries. And this happens when there is societal or widespread prevalent buy-in on how male or masculinity and men are considered as superior, and femaleness, femininity, or women and girls, by extension, are considered as inferior. And when this is institutionally sponsored, even by state governments or the law, and also in the home and at the workplace, and also in places of worship, then what we have is a systemic oppression that is based primarily on gender. And this leads to gender-based violence. I know that almost all of you here already know this, but it cannot be overstated, because unless the tools that we have at our disposal is aimed at redressing or countering gender binaries, tools like the law or maybe education, gender kind of sensitization will not adequately work. And what we hope to be able to arrive at is gender justice. And also, as Rim has mentioned, is gender justice not just for women, although women, of course, the woman question that is with regard to feminism needs always to be the paramount question. We must never lose sight of that, but also the fact that feminisms today, through feminisms of color or feminists of color, are cognizant that we have multiple axes of discrimination. And so someone could be doubly, triply, or quadruply marginalized, sidelined on account of not just their gender, their sexual orientation, their race, or in the context of India, their caste, or their class, even nationality and religious affiliation. So the problem is, because I deal primarily with the intersection of rights and religions, one of the problems that lead to deadlocks or impasses is the contestation between universalism and cultural relativism. So what I want to offer is a radical solution. It's not to disregard cultures and religions. I know it's got bad press among human rights advocates, but to offer a feminist critical relativism or feminist critical relativist positioning as a position that has, in some situations, and that's adopted by some human rights organizations, that has worked. And fundamentally what this is that it's a combination, or it works on the intersection of universalism and cultural relativism. So here, by definition, universalism would be a respect for human rights, which is considered a universal value. But in the context of Malaysia, for instance, we have former prime ministers who discount human rights as a foreign value, as a foreign value system, and prop up Asian values as the way to go. So when we have that, sometimes we have cultural and religious cultures and religions, cultural religious practices that are used as barriers, or could be weaponized against human rights. But and of course, then you have extremities of a universalist approach, which is a moral imperialist approach, and that is a non-tolerance against any form of cultures and religions, or the excess of a cultural relativist position would be a moral relativist position, which condones harmful cultural and religious practices. So what I mean by a critical relativist position is a position that does not disregard, that regards both a universal value as well as respects the integrity of cultures and religions, except where they are harmful. In this next slide, the Beijing Platform for Action is the outcome of the fourth and last World Conference on Women. So this is the Beijing Platform for Action. Many of us are familiar with the notion of religious fundamentalisms, but less so political fundamentalisms. So what I want to say from this slide, and these are two quotations that are taken from paragraphs 24 and 9, respectively, in the left and in the right column. So religious fundamentalisms has to do with, it leads to gender stereotyping, which Rim has mentioned. And this is a position taken up not only by cultural relativists, but also in particular by moral relativists. And that is condoning, for instance, harmful religious and cultural practices. But we also have political fundamentalisms that are actually embedded in human rights or women's rights conventions and documents. And if you look at the quotation, so conventions or documents like the Beijing PFA already prescribe that in the case of a contestation between universalism and cultural relativism, that universal values has to take precedence. And my point of contestation is that when you err on the side of saying that A should take precedence over B or vice versa, that is a case ripe for impasse or deadlock, and no one can get any further. And people who are already made vulnerable are going to be made more vulnerable, even by the law. So within 10 minutes, that's just enough time for one case study. And how would a feminist critical relativist response be applied to child or early marriage? So in the context of Malaysia, we are 32 million today. And Malaysia is, the majority of Malaysians are Malays ethnically. So I'm Chinese. And in terms of religious persuasion, the majority of Malaysians are Muslims. So Muslims in Malaysia are subjected to a dual legal system, that is the Sharia or personal law, and also the secular law, which is the Criminal Procedural Code. So this was reported in the New Straits Times, which is one of the oldest newspaper in the country. And there are 3 quotations here. So on the case of early or child marriage, there is no contestation. Child marriage is not a good thing. It is a harmful practice. Some people think it's cultural. Some others, use religion to justify it. It's a harmful practice for girls. And in the case of Malaysia, this happens predominantly among Malay families and also indigenous communities, indigenous peoples' communities. So on the left is a quotation. Sorry, that's my alarm saying that I should stop now. But just very quickly, on the left is a quotation by a man, a 41-year-old Muslim Malay man who has married an 11-year-old Thai girl, and she is his 3rd wife. So the quotations on the right is what I want to draw your attention to. Girls Not Brides, some of you may be familiar with this very powerful organization. It's a worldwide organization that advocates against early or child marriages. And what they have said is a statement that is richly informed by the rights of the girl child and the rights of women. But what I find, more intriguing is the 3rd quotation on the bottom right of the page, and that is by the Sisters in Islam, which is a feminist Muslim group in Malaysia. So what the Sisters in Islam do is that they go back to the source, which is the Quran for Muslims, to show that the affirmation of a woman or a girl child's human dignity, a fundamental human dignity, is also enshrined in the Holy Book. So the Sisters in Islam use what I term as not just a rights-based, but also a faith-based approach. And of course, as feminists, they work within a feminist critical relativist positioning. So that is basically my very short presentation. And I wanted to end with this quote. It's taken not from any legal scholar. It's taken from Pope Francis. Our future is not monochrome, because it's a nod to differences that matter among us. And once we're able to recognize that, and that is translated into law and into our education in the way that we relate to one another, then there is possibility for a kind of radical hope that is transformative. Thank you very much for your attention.
Thank you so much, Sharon. I too, again, I am really enjoying listening to you all, because there's so many things in common. There's so many of these questions that I have about how do we make a system responsive to women. And here, I think sometimes it's a frustrating conversation, because there's so many factors involved in trying to make spaces safe for women. And you have also struck similar questions and have faced similar problems. So again, looking forward to asking more questions later. Vita, can I invite you to speak and tell us about your experience in Africa?
Thank you so much, Nia, and thank you to BD Center for Legal Policy for inviting me. I think I also shared like the same sentiments as Dr. Sharon, that I didn't feel like I could be of any value, although I had agreed to, go ahead, because this is more of looking at laws. But I guess based on my background of having done social legal studies and research on gender-based violence and mitigation and responses to that, I am very honored to have been part of this panel discussion. So in my presentation today, unfortunately, I'm so sorry that I was having technical issues with my laptop, so I won't be able to show up my slide, but I'll do send it to you. So I'll be looking at the role of criminal laws in combating violence against women in South Africa and Zimbabwe. as this is where most of my research and most of the work that I've done is based on. In terms of laws that are related to violence against women in Zimbabwe, there have been quite a lot. And one, I will start with the Constitution of Zimbabwe. Zimbabwe has an array of domestic legislation highlighting violence against women issues, and has made quite an extensive progress in making changes and formulating policies around prevention and protection of women and girls from all forms of violence. And the first is the Constitution of Zimbabwe of 2018, which provides and supports all the other legal frameworks around violence against women in Zimbabwe. And the second piece of legislation that we have is the Domestic Violence Act, which speaks quite extensively and it also includes things like cultural and customary rituals and practices, virginity testing, female genital mutilation, the pleading for girls, and purpose of appeasing spirits, abduction, child marriages, and forced wife inheritance. And in terms of like the general statutory or criminal laws or penal codes, we have in Zimbabwe what we call the Criminal Law Codification and Reform Act. And in Chapter 70, that's where it speaks, Section 70, that's where it speaks more, elaborate on how to then deal with perpetrators of violence against women. Then there are other laws that also have like an impact that are not really specific to violence against women, but have an impact on violence against women in Zimbabwe. And that's the Children's Act. There's the Married Persons and Property Act. There's the Deceased Estate Succession Act. And there's also the newly amended Marriage Act, which was amended or approved sometime last year. And then in terms of how then we deal with the perpetrators, the procedural laws and processes, there's the Criminal Procedure and Evidence Act. That is in terms of Zimbabwean laws. But despite having all these laws and all these other policies that have been formulated over the years, and the latest being the high-level political compact, which was formulated last year, with regards to how Zimbabwe can then best deal with gender-based violence and issues to do with violence against women and girls. There's still a number of incidences of gender-based violence. So we may have all these laws, like what Irene said earlier on, that dealing with violence against women is not only putting the laws down because they are there, but people will still act the way that they want to act. They don't have the legal consciousness that is needed, or the legal translation as well, even of like international human rights laws into like domestic frameworks is still quite lacking. And there's a lot of gaps within these national laws in Zimbabwe. There's still a lot of gaps, and in terms of implementations and aligning them to the policies as well. The latest Zimbabwe Demographic Health Survey says that 40% of women between ages of 15 and 49 have experienced violence in their life, be it physical, emotional, or that is highlighted within the Domestic Violence Act. Also, in Zimbabwe, a lot of women experience violence against women as a result of gender inequality and discrimination in general. I'll expand more on this as I go on when I'm trying to link the two countries together. I'll go on and talk about laws that are related to violence in South Africa. So just as like Zimbabwe, South Africa has taken several steps towards reforming its legislation. Even last year in 2022, they amended quite a number of laws. And this was because of the COVID-19 pandemic, which saw a rise in cases of gender-based violence and violence against women in general. And they took a step in trying to amend and trying to make the laws more stern or more draconic. Let me just try to put it that way. And it has the most impressive, arguably the most impressive Bill of Rights. And Chapter 2 of the Constitution of South Africa provides for the right of for women to be free from violence, either in private or in public spaces. And South Africa also has the Domestic Violence Act, which was amended recently in 2021. It also has the Protection from Harassment Act of 2011. And when we go to general statutory law, it has the criminal law, which is specific to sexual offenses and related matters, which then deals with perpetrators of any forms of violence against women. It also has the Criminal Law Amendment Act, which deals with the perpetrators. The other laws that are that impact violence against women that are also linked to dealing with the pandemic or epidemic of violence against women is the Marriage Act, there's the Matrimonial Property Act, there is the Civil Union Act, and then the Interstate Succession Act. In terms of the procedural law, there's the Criminal Procedural Second Amendment Act, there's also the Criminal Law and Sentencing Amendment. So those are the laws that are in South Africa. But again, because South Africa has a dual legal system, it has created quite a lot of loopholes for various groups, including women and girls. Where this loopholes then come in is that when we have customary law and we have the civil law. And when dealing with issues to do with inheritance, issues to do with divorce or separation matters, the customary law sometimes overlaps the civil law. And then it creates the loopholes in how then we can best deal with issues like inheritance, issues when it comes to separation and divorce, who gets what, and how then women are then victimized in all these processes. And despite actually South Africa having amended all these or passing the new laws in early 2020, gender-based violence in January last year, according to the crime stats of August last year, reflected that there was limited improvement on protecting the women's rights. And more than 11,000 cases of gender-based violence against women were reported from January to August of last year. So we can already see that violence against women is not only, it's not about the laws. We may put all these laws in place, but at the end of the day, especially within the Southern African context, you can see that a lot of it is deeply embedded in how we are socializing our men and our boys. It's deeply embedded in the patriarchal society, within our cultures, within how we relate to each other. And a lot of men feel very threatened or they feel very threatened by the empowerment of women. There are case laws actually in South Africa where a lot of men have raped women and saying that they were trying to correct, like correctional rape, or especially when we look at the LGBTIQ communities, a lot of men have gone on to rape women and trying to insist that, we are the men and there's no way that you can turn into a man, because that's just not it. And already we can see how the men are being threatened by this. They are being threatened by the empowerment, by the freedom. It's fortunate enough that South Africa has laws in place to protect the LGBTI community. But in Zimbabwe, unfortunately, we don't have those laws yet. In terms of how then law translates into action, it's a whole different story when we are talking about how laws are translating into action. We have to look at it in a holistical. Gender-based violence is something that we have to look at a multi-sectorial and multidisciplinary level, and take a multidisciplinary approach. We cannot look at it in a linear way that we're just looking at the laws and we are going to put the laws, we're going to put the national policies. It will not work. Well, in the context of Southern Africa, it will not work. There is need to involve quite a number of key stakeholders, from top level to bottom level. So that is your government ministries and department, your judiciary, the legislator, and formulate independent commissions. The media, like how Sharon, sorry, was it Sharon or it was Rima who highlighted that media often actually re-victimizes these women when it comes to how they report. So it's involving all those actors at different levels so that they may be able to curb the roots of the problem, because the roots of the problem first has to be dealt with. Laws, yes, we can put in place, but if the root of the problem then is not dealt with, and you keep on putting more draconian laws and more and more and more, it's not going to help in dealing with what the problem then is. So we have to, especially within the Southern African context, it's quite important to integrate even traditional leaders and institutions, faith-based organizations, because a lot of the Southern African population are Christians or believe in one or the other religion. And it's going down to those people that then we need to go and be able to formulate strategies and ways in which that we can re-socialize our men, re-socialize our boys. It's dealing with how men think of women, how men are seeing women, how we are choosing to socialize with them from a very young age. That's how then I think we can be able to deal with violence against women. I would also like to just say to applaud Zimbabwe at this moment, but it will take quite a lot of action. They have done quite a lot in terms of trying to involve even development partners, trying to take a human rights-based approach in terms of dealing with this. But although there are still high levels of incidences of gender-based violence, we really need to go deeper and make sure that there is increased awareness of rights to the communities. There's increased awareness of how we are dealing with it. So it's violence against women starts from the home. It starts from your house and my house and the next house, how we are then going to deal with it, how we are socializing with each other, the values that we're going to instill in it with each other. Yeah, I think that's where I will end my presentation.
Thank you so much, Vita. I think what was very evident from your presentation is that the issues that Zimbabwe and South Africa are facing are similar to India, because we have a whole spate of laws and the state of implementation remains very poor and violence against women continues to rise. So this seems to be a problem that all of us face and that seems to be shared across different jurisdictions. So what I have gathered from everybody's presentation, of course, and what I have believed is that criminal law or law itself is not really the answer. It is only one tiny step in this larger solution. So this is a shared experience of all of us. And so this was, of course, a primary question that I had getting in about what role does criminal law play in combating violence against women? And so my question, this is to all three of you, is actually this: what role does criminal law play? Because I have found it to be largely ineffective, but we still seem to need it, because as Vita also said that, unfortunately, we don't have, or Zimbabwe doesn't have laws that protect LGBTQI community against violence. So on the one hand, we find law to be inadequate. On the other hand, we seem to need it. So what really does law do for us is my question to all three of you.
Can I answer?
Of course, please.
I think, like I said, that it has to be a multi-sectoral approach. Yes, laws have to be put in place because we then have to deal with the perpetrators. But even if you put these laws and not have people who are legally conscious, who know that, what, if I'm to go out there and I am going to rape a woman, there are consequences. But if we don't deal then with what has led that man to go out there and say, I am raping this woman, I'm going to beat this woman up.
Vita has frozen. Vita, I think we'll come back to Vita. There seems to be something wrong with her video. Reem, can I pose this question to you for now? I also had a follow-up question for you, because you said reparations are necessary. Now, reparations within the scope of law, within the scope of criminal law, or should we be looking outside of the legal system entirely when we're thinking of reparations? One. And two, if we are focusing very heavily on deterrence or on sending the perpetrator to jail, what should we focus on? Is sending somebody to jail, does that give any satisfaction to the victim? Or is what the victim looking for is just to continue normal life?
Yeah, I think, well, I first of all agree with what my colleague started by saying, and she was cut off. It's really, the legal avenue is just one of many things that have to be in place. And let's also be clear that many victims will not have access to legal justice mechanisms. And the first, let's say, line of justice they have at their disposal is also traditional justice mechanisms, right? I think
Yes.
In principle, traditional justice mechanisms in themselves are not a bad thing. Of course, we have to see to what extent they are also in line with international human rights standards and available. But they are the ones that most likely will be available to victims, and they should not be forced upon the victim. Reparations, I mean, you all know the definitions of reparations, and reparations are not just about legal justice. On the contrary, there are many other things that that form part of reparations, including recognition, apologies, satisfaction, and also to be provided with compensation for the damage that was done. It can be financial or otherwise. So, and going back to the point I made in my presentation, that the most important thing is that the victim decides what justice looks like, and it's not imposed on them what justice looks like.
So for it to be victim-centric, do we then reimagine the criminal justice system? Because the criminal justice system is across the world largely accused-centric. So for the victim to decide, for the woman to decide, do we change how we look at the system? Do we just do we go through a parallel system? How do we make it victim-centric?
I think you need to look at the gaps in the justice system, which is not just legal, as I said. Look at all aspects that contribute to the denial of justice. So, as we said, also social norms, religious norms, the bigger macro system, so to speak, of the bigger ecosystem in which violence is taking place and in which we are trying to seek justice. And it's really imperative, first of all, that there is political will. I mean, you don't just launch processes as an authority if you know you're not going to go ahead with them and implement the recommendations. But most importantly, that you involve all relevant stakeholders. So that also includes victims, victim organization, women groups in all their diversity. So also look at groups representing minority women, women belonging, as we said, to different ethnic groups, religious groups, women of diverse sexual orientations, gender identities. So you need to look at all that, and you need to involve them in the design and the monitoring and the implementation. So even once you have in place a legislation to address these issues, you have to then follow up in a few years down the line to say, okay, so what happened to this reform that we did? How has it changed? What does the data tell us? Are we collecting better data? There is no quick fix, and there's no one piece of the puzzle. You have to have the whole puzzle in order to be able to get somewhere.
Thank you. Now, I have a question that I'm going to throw to Sharon, but Reem, you mentioned this in your presentation, and I know Sharon has mentioned this in a podcast that I listened, that having female representation is critical to creating more just mechanisms for women. Now, my question or my confusion around this is that patriarchy runs so deep that one, our structures themselves are patriarchal, and two, there's women have bought into patriarchy so completely. It's not just men who need to be re-socialized, it's also women. So how much would gender or how much would female representation in structures that I believe, or this is again, I'm adding a bias, but here is that structures themselves are so patriarchal. What will female representation in this do?
Vita is back. Thank you so much, Neha, for that question. I also wanted to very quickly respond to your first question on
please, sorry.
What do laws do for us? And I guess, justice, it's important to have laws because they signal that not just lawmakers, but the people who, the politicians and other stakeholders are cognizant that there is a particular, aspect of or problem that needs to be addressed, that something needs to be criminalized and so on and so forth. But justice should not just happen within the courts or tribunals, but also happen outside of it. And that was the point that I tried to make in my presentation, and that there needs to be a buy-in by men, but also by women, which your second question implies. Because there are cases where if a girl has been raped in the home by her father and she turns to her mother, very often we hear through the media that the mother chooses to disbelieve her own daughter, perhaps for the sake of just holding the abusive environment together, because maybe she's completely financially dependent on the abusive man in the family. So you're right to say that patriarchy runs so deep, and when various institutions sponsor, tolerate, turn a blind eye, or even provide an enabling environment in the case of sexual harassment at the workplace, provide an enabling environment for crimes against women, injustices towards women, then we need, a multi-sectoral approach. We need what I've termed as an intersectional approach, because multiple institutions, and these are very powerful institutions, intimate ones as well, because it starts with the family, and also then cultural and religious spaces. And these inform so much of our decisions regarding our sexual and reproductive health and rights. So women's representation, we'd like to think that, radical hope or bringing about transformative hope should start with women, but it should not end with women. And so research has shown, and global data, that when boys and men are involved in combating violence against women and the girl child, that, magic happens. And it goes back to having very honest discussions in the home, in the classrooms, and in wider society. And of course, social media, which is today such a powerful platform, that moved the whole Me Too movement. These are very important tools in addition to law. So the legal system, we mentioned an interesting word, and that is ecosystem. And it's so true that, agitating for change needs to be multi-pronged. It needs to happen in all of these institutions. There needs to be adequate buy-in by not just men, but also women. And I think, more people just need to use the F word, or maybe if they don't, at least in terms of action or praxis, really live that out. Yeah, really live that out. That's my response. Thanks.
Thank you. I now had a question for Reem and Vita, because both of you mentioned media and that it makes matters worse. Could you, I kind of know what you're saying, but I want, how does it make it worse? What does it do that makes things worse for women? In reporting crimes and talking about the situation, how does it make it worse? And what could it do differently?
Yeah, I think I answered that question in the chat. Media often tries to cover a story, get attention, ratings, be sensational. And in doing that, it often ignores issues to do with confidentiality, privacy, dignity, non-traumatization, non-re-victimization of the victim. Reporters are also influenced by their own gender stereotypes. As we said, they also cannot be taken out of the context in which they live, the ecosystem. So they might also add often blame to the victim, that if she was raped, it was her fault because of what she was wearing, because she, encouraged the rapist, flirted with him, you name it, huh? And this we see really in countries, in many countries across the board. Just a few weeks ago, a very highly educated academic, I forgot exactly her position, but she was killed by her husband. And when you look at in the UK, and when you look at the way at least one media outlet reported on it, it's almost as if they justified her killing because she was too successful, more successful than her husband. It's as if giving him the license to kill her because he was jealous or couldn't deal with a more successful wife. And this kind of language is, of course, incredibly problematic. It reinforces these kind of stereotypes, but it also blames the victim. And media doesn't realize how strong of a role they play. And of course, something else we didn't talk about at all, but is very problematic, is that online technology and social media platforms are in today's age and place are really the main engine of gendered violence against women in public life, in political life, and continue to be largely unregulated in many parts of the world. So that is something we also have to get a grip on.
Thank you. Vita, would you, I think Vita has, yes. Hi, Vita, welcome back. Is your internet doing better?
Yeah, sorry, I don't know what happened. I just lost my connection. But to answer your question and also to add on what Reem said, yeah, I wanted to speak especially with regards to how social media then fuels violence against women. I think I'll speak in terms of Zimbabwe. Like a few weeks ago or a month maybe ago, there was a case of a woman who had an extramarital affair with someone, and now she was like, I don't know what really then happened. The husband reported her saying, well, what had happened. And it was all over Twitter. It was all over Instagram. It was all over, basically all over, even on Facebook. And when I was looking at that case, I was thinking, and looking at the comments as well being made by people, they are literally victimizing this woman. They are literally trashing, like putting her down the drain, and saying all sorts of things. Now I could only imagine if she has been seeing that, how then she must have felt, because it's a form of psychological abuse that we never think about, the impact then it has, the ripple effects then that it has. It's another form of abuse that we actually don't think about, even the way that we respond to in the comment section on Twitter, on Instagram, and in terms of just the general media. Sometimes they over sensationalize a story, like what Reem was saying. They over sensationalize a story so that they could get ratings, get more viewers, and in doing so, they are re-victimizing the person, or they're actually putting the perpetrator of violence on a pedestal, literally and which I feel like it sort of reinforces patriarchy. It sort of reinforces how then we are viewing violence against women, how then we are dealing with it. And also, it's then making or sensitizing reporters on how best to handle issues, especially where there's been some form of abuse, or there's been some form of violence happening that is perpetrated against women or girls or anyone for that matter, how they then have to be sensitive in terms of confidentiality, like what Rima was saying. It's quite important then how then you're addressing it and how you are reporting the story. They can also be actors in trying to combat the violence by actually being sensitized on how to report such stories, and how then we need to socialize in a different way, teach our men, our boys in our household on how best we can be able to combat violence against women, so that we are not a generation or generations of just continuous violence. Yeah, and that's what I will have to say.
Thank you, Vita. I actually have many questions, but I realize that we are beginning to run out of time, because this is just an endless topic and there's so many questions that one could engage with. But I'll now take on some. We have none. Okay, all the questions have been answered. That's great. So our viewers are happy with the questions and they have been answered. So I will thank you all for making yourself available, giving us time to speak to us. I've had a wonderful time. I hope this was useful for our viewers, and I hope you learned something. Thank you all so much for being here and giving us your time.
Thank you for having us, and thank you for the participants for their very engaging questions and interest.
Thank you so much, Neha, for inviting us.
Thank you, Neha.
Thanks. Bye.
Bye-bye.